Good evening to all of you. We continue from where we left last time. We discussed about section 11 of the Guardian and Wards Act. Here it is said, once the application for appointment of guardian is filed under section 10, the next step is reached where the Sherasadar of the court prepares the office note, puts up before the judge, and if all the formalities have been satisfied, then the court orders the OP to be registered, and accordingly the OP will be registered and given a proper number and allotted to a particular judge. Either the judge keeps it for himself or allots it to the additional district judges to be disposed of according to law, and a date is fixed for appearance of the respondents, and also the date is also fixed. But one important thing you must remember in this section 11 is that paper publication is also ordered. That is, you will have to publish it in the paper. Anyone who is having any objections for the allowing of the application or hearing of the application can file a petition and be present in the court and then be entertained as a party, because all concerned means it includes everyone. That is the reason the hearing is preceded by giving a paper publication in a newspaper which is widely circulated. And once the date of hearing is fixed, the other side appears before the court and then files a counter, and then the evidence is led, and then the arguments are heard, and then the orders are passed accordingly. This is what is the purport and interpretation of section 11 of the GNW Act. Today, we go further by dealing with section 12. This is almost akin to your civil procedure code, where suppose you file a suit for perpetual injunction, you may also ask for temporary injunction. That is by filing an out of order. The same way the out of order, the IA is checked and put up before the court, and the court, after hearing both the parties, passes an appropriate order. So section 12 is almost similar to that. Section 12 says a person who applies for appointment of guardian, if there is an urgency, he can file an application under section 12 to grant temporary custody of the minor who is in the custody of the respondent number 1, who is his wife or any other person. Then in that case, the application will have to be clearly mention what are the circumstances under which you are claiming temporary custody. The reasons will have to be spelled out, and the other side is given an opportunity of filing the counter. And once the interlocutory application of the IA is heard, the court passes appropriate orders granting temporary custody of the minor by asking the respondent number 1, who is having the custody of the child, to produce the child into court to be handed over to the applicant for temporarily till the disposal of the application. Please don't bear it in mind that once you file a petition for temporary custody, it will be ordered automatically. It is subject to the satisfaction of the court that sufficient reasons are shown where temporary custody can be granted to the applicant. So on sufficient reasons being shown, the court may order temporary custody and direct the respondent number 1 to produce the child into court to be handed over to the applicant temporarily till the disposal of the application. And this is the purport or interpretation of section 12 of the GNW Act. Then we go further, go to section 13. The court can record evidence. Here, please remember, as far as GNW Act is concerned, once it is filed, the counter is filed, evidences on both sides are recorded as per the provisions of the Civil Procedure Code, and then on the relevant material placed before the court by way of oral testimony or documentary testimony or any other material, the court has got the power to order the application. So without recording the evidence, the petition under section 12 or section 10 cannot be ordered. So one important thing you must remember is, under the principles of Ardi Altrum Partum, no man should be condemned or no man should be condemned unheard. So equal opportunity is granted to the opposite side to put forth his or her objections to the allowing of the application. This is what section 13 deals with. Section 14 says, If proceedings for the appointment are taken in more than one court, the court can stay the proceedings before itself. Suppose multiple cases are filed. Suppose the wife herself files a case for appointment of guardian, and that is proceeding to this present application. Till that is disposed of, this petition will be stayed or will be kept in suspended animation, awaiting the result of the previous GWOP which has been filed either by the respondent or by any other person who is interested in securing the guardianship of the minor child. Then section 15 deals with court can appoint separate guardians if the minor has multiple properties. Sometimes it's not possible for one guardian to discharge his duties faithfully, diligently, with prudence, and that is the reason why multiple guardians also can be appointed regarding the various properties owned and possessed by the minor. So there is no bar for appointing multiple guardians. For property number 1, one guardian; property number 2, one guardian; property number 3, one guardian, like that. Multiple guardians can be appointed if the properties are located at different places other than the jurisdiction of the court. This is what section 15 lays down. Then section 16 deals with appointment or declaration of a guardian for the children, that a joint custody order be made for property beyond the jurisdiction of the court, and the production of the certified copy of the order appointing the person duly appointed, and give effect to that order. Suppose, let us say, multiple guardians are appointed, then a certified copy of the order passed by the various courts where the proceedings are pending, it has to be filed so that it comes to the knowledge of the court, and the court can deal with it in a manner appropriate and according to law. That is what section 16 says. Then section 17, welfare. What are the conditions, considerations which are important, which has to be satisfied for appointment of guardian? One is primary condition is that the welfare of the minor, whoever is appointed as a guardian, whether it's a father or the mother, who is a fit person, who is a proper person, who is a competent person, who has got the financial capabilities, who has got a better chance of looking after the child better than the other, these considerations will have to be taken. And the first consideration is, the paramount consideration is, welfare of the minor has to be taken into consideration. Second one is that sex and religion of the minor, and the capacity of the guardian, and his nearness to the minor by relationship, the wishes of the deceased parent, but not against the will of the minor. So before appointing a guardian, sex of the minor, financial capability of the guardian, then capacity of the guardian, competence of the guardian, and the qualifications of the proposed guardian will have to be taken into consideration. But before a minor guardian is appointed, the wishes of the minor has to be taken into consideration, and the minor has to be examined with whom he wants to live and with whom he wants to reside. That is what section 17 says. Then section 18 deals with where a collector is appointed or declared by the court to be authorized to act as guardian of the person and property of the minor. Then section 18 deals with, suppose both the husband and wife are incompetent, the collector is appointed as the guardian to look after and manage the affairs of the minor, not only as far as his person is concerned and as far as the property is concerned. A written order is passed whereby the collector takes over the responsibility of looking after the person and property of the minor in all respects. Then section 19 deals with, a guardian cannot be appointed when the minor's property is under the supervision of the court of wards, or to appoint a guardian when a minor who is a married person, female, and when husband is unfit. Here, as far as males are concerned, there is no problem at all. But as far as female children are concerned, the husband, once the female child gets married, the husband for all practical purposes becomes the guardian of the body and soul of the female child. And in that case, once the husband is there, the father or mother of the minor female is not entitled to be appointed as the guardian unless and until the husband of the female is unfit, incompetent, and incapacitated. The paramount interest of the minor will have to be taken into consideration before a guardian is appointed. So normally speaking, a female child, once she is married, the husband becomes a guardian, and he cannot be a guardian unless and until he proves his fitness, he proves his financial capability, he proves his capacity to look after the female who gets married to him. Unless he is unfit, he can be appointed as a guardian. Then where the father or mother is unfit, here, suppose the father and mother both are unfit to be appointed as guardian, both are wayward, both lead an irresponsible life, then the paramount interest of the minor is affected. That's the reason both cannot be appointed. Third one is, under the court of wards, competent to appoint a guardian of the minor person. I told you also, there is an institution called court of wards. In Urdu, it is called Sarfakas Mubarak. In that case, both the mother and father are unfit, incompetent, incapacitated. Then in that case, the Sarfakas Mubarak or the court of wards administers the properties and also looks after the welfare of the minor. And then section 20 deals with fiduciary relationship of a guardian. He must not make any profit out of his office. Fiduciary, what do you mean by the word fiduciary? Fiduciary means once one person is at dominating position compared to the other and then uses that position to his benefit and to the detriment of the other, is said to abuse his fiduciary capacity. As far as the guardian and ward is concerned, the guardian stands in the capacity, in a fiduciary capacity compared to that of the minor, and his conduct must be above board, and he must conduct himself in a manner beneficial to that of the minor. And please remember, he cannot use the guardianship for his own benefit, make profit out of that office and try to sell away or try to alienate the property of the minor. Then section 21 deals with, when a minor is not competent, a collector can be appointed as guardian. Suppose, let us say, when a minor is not competent, please remember there is no bar that a minor can also be appointed as guardian. But when the minor himself is incompetent, then in that case, the collector is appointed as the guardian of the person and property of the minor. That's what section 21 deals with. 22 deals with guardian entitled to remuneration for his services. Suppose, let us say, father and mother. Father cannot expect remuneration from his son. But the question is, if a third person is appointed as a guardian, whatever services he renders for the benefit of the minor, he is entitled to be remunerated, he is entitled to be compensated, he is entitled to be reimbursed for the expenses which he incurs in maintenance of the minor. That is what 22 says. 23 is collector subject to the control of the state government. Once a collector is appointed as the guardian, in the absence of the father or mother or the minor concerned, then the collector takes out the responsibility, and whatever acts and deeds is done by the collector in the color of office, he has to account for it. He is responsible for all his acts and deeds to the state government under which he works. That's what section 23 deals with. Then 24. Guardian should look after the welfare and health of the minor. Please remember, just because you are appointed as a guardian, just because you are declared to be the guardian, just because the court finds you fit and competent to be appointed as a guardian, you have to shoulder a lot of responsibilities. You have to always act for the welfare of the minor, look after the health of the minor, look after the education of the minor, and use the funds for the benefit of the minor, not for yourself. That is what 23 deals with. 24 is that guardian should look after the welfare and health of the minor. 25 is, if a ward is removed from the custody of the guardian, the court can make an order to restore the ward, and the ward may be arrested and delivered to the custody of the minor. Here, custody of the minor. Here, suppose let us say a ward has been removed from the lawful custody of a guardian. Then in that case, the court can order arrest that minor, bring him to court, and hand him over to the person who has been declared as a guardian of the court. So in other words, kidnapping, abduction, and all are safeguarded by this. Court has got enormous powers under section 25 to order arrest of the minor wherever he is, from whomsoever custody he is, and bring him to court and hand over the child to the guardian who is properly appointed. This is something akin to the Civil Procedure Code, which is restitution. Restore the minor to the proper guardian who is appointed, remove him from the custody of the person who is holding him, or who has removed him from the custody of the guardian. Then the minor is arrested, brought to the court, and then handed over to the person who is declared as a guardian. Then section 26 says, the guardian except the collector shall not remove the ward from the jurisdiction of the court. Here, suppose the G&W proceedings are pending before the Hyderabad court. It is the endeavor of the guardian except the collector not to remove the minor from the jurisdiction of the court. The minor should always be within the watchful eyes of the court, and that is the reason why section 26 has been provided. Then section 27 deals with the guardian shall manage the property of the minor with ordinary prudence. That means since the guardian stands in a fiduciary capacity compared to the ward, he must exercise utmost caution, and he must tread carefully, and he must see that the welfare of the minor is safeguarded at all times, and his office shall not be misused for personal purposes, and he shall not act in a manner detrimental to the interests of the minor, and that's the reason why he must act with due diligence and without any negligence and for the benefit of the minor. Then, sir, section 28. Where the guardian has been appointed by will, he is power to mortgage or subsequently any restriction that may be and under the instrument. Suppose a guardian is appointed through a testament, or a guardian is appointed through a will, or a guardian is appointed by an instrument. The question is, the terms and conditions of his appointment has to be discharged carefully. It has to be done with due diligence and without violating any of the restrictions that has been imposed by that particular instrument. That is what section 27 deals with. Then 28 is, except collector, the property cannot be mortgaged or leased without permission of the court. See, without the permission of the court, a minor's property cannot be alienated, minor's property cannot be mortgaged, minor's property cannot be leased, minor's property cannot be parted with except taking the permission of the court. In this regard, I give you an explanation, sir. Suppose, let us say, the minor loses his father or minor loses his mother. Then in that case, what happens is, the minor is in the custody of a near relative. Then in that particular case, suppose let us say accident benefit comes, that is under the Motor Accidents Claims Tribunal, an award has been passed by the tribunal granting compensation to the minor. Then in that case, whatever compensation is granted, what the court does immediately is, it asks the guardian to open a savings bank account and then give the passbook to the court, and then whatever award is given to the minor by the due to the accident, that amount will be invested in a fixed deposit, and the guardian will be allowed only to draw the interest and then use it for the welfare and maintenance of the minor and for his education, etc., etc. Or if any contingency arises, that some money is required for education purposes or for building a house or for performing an obligation, then in that case, a permission petition has to be filed before the court which passed the award, and then whatever money you want to draw, the court will not allow you to draw the entire money, but you have to explain the circumstances why you want to withdraw the money, which stands to the credit of a minor of whom you are the guardian, and the court permits you to withdraw that money and render proper accounts for the amount spent towards the education, health, and other needs of the minor. So this restriction is imposed as far as the Guardian and Wards Act is concerned, as well as the motor accidents claims are concerned. Why? Because if the entire amount is withdrawn, the guardian may abscond, guardian may abandon the child and go away and spend money and then live lavishly. So these checks and balances are also imposed under the various enactments. And suppose you want, let us say you want to sell the property of the minor for the purpose of his education, so on and so forth, then permission of the court has to be taken. Why you want to draw the money, how you are going to use that money, how you are going to utilize that money, whether you are going to utilize it for yourself or whether you are going to utilize for the welfare of the minor, the circumstances will have to be narrated properly, and then the court permits you to sell the property. And please remember, once you want to sell the property of the minor, permission of the court is absolutely essential. You will have to take the permission of the court to alienate the property, show sufficient reasons, and the sale consideration is derived from the sale of the property. That has to be deposited into the court, and the court invests it in fixed deposit, and the guardian will be allowed only to draw the interest from the fixed deposit, but most probably the court will not allow you to draw the entire amount, because some future amount will have to be kept for the welfare of the minor, and the guardian cannot gulp the entire money and leave the minor unattended to. That's what section 29 deals with. Then section 30 deals with what is called voidability of transfers made in contravention of section 28 to 29 is voidable at the option of any other person. So as far as any transfer is made without permission of the court, without explaining the circumstances why that amount has been withdrawn, then the contract is voidable. Any other person can definitely question it, and then the transaction will be set aside by the court because for want of proper permission. That's what section 30 deals with. Then section 31 deals with court can grant permission only in the case of necessity for an evident advantage of the ward. Please remember, when is permission normally granted, sir? Permission is granted, you must satisfy the court, it is for the benefit of the minor, it is for the welfare of the minor, and that money is required for his educational expenses. You want to send that person abroad and you require educational expenses, or you want his maintenance expenses. For that purpose, if you are able to satisfy the court that it's an eminent necessity for the welfare of the minor, court grants permission. If you do not show the necessary particulars, the court can reject your application to withdraw the money. Then 32, court can vary the powers of the guardian to the advantage of the minor. So sometimes when acts of misdemeanor, acts of defiance has been brought to the notice of the court by the rival claimant, the question is the powers can be varied or the ribbon can be cut, whereby the powers of the guardian can also be restricted by the court at any time when it has been brought to the notice of the court that the guardian is acting contrary to the interest and welfare of the minor. That's what section 32 says. Then 33 is court can apply, the guardian can apply to the court for its opinion, advice or direction or any other question respecting the management and administration of the property or the ward. Sometimes what happens is your mind gets blurred. You have got some doubts, you want some opinion, you want some advice, you want some suggestion. Then in that case, under section 33, you can apply to the court as a guardian and seek for legal advice, seek for the advice of the court, and seek for the pronouncement of the court, and the court can give you proper directions on which the property has to be managed, property has to be administered, how the welfare of the minor has to be taken into consideration. All these things will be answered by the court on an application filed. Then 34 deals with audit can be made and remuneration be made from out of the income. Please remember, sir, except the father and mother, no other person would try to get remuneration from the income of the minor. But if any other person is appointed as a guardian, naturally it doesn't do anything free of cost. Then in that case, whatever remuneration, reasonable remuneration he has to receive For the services rendered, the court would order the remuneration to be paid from out of the income arising out of the properties owned and possessed by the minor, provided it is properly audited and the audit report also is filed into the court. Then 35 deals with suits against guardian when administration bond is taken. 35 says, where bond is taken for accounting, he may receive in respect of the property, the court may, on application for where administration bond is violated, the court can assign the bond and that the person can sue on the bond as a trustee. So when the question is, when administration bond is given, administration bond is something like bond for good behavior and all. When the guardian gives a bond before the court and says, sir, I am giving you a guarantee that the monies which are received, the incomes which are received from out of the properties of the minor, that will be invested properly, proper accounts will be rendered, proper audit will be done, and also suppose let us say the guardian violates the administration bond, then in that case any other person who is interested to safeguard the interest of the minor can sue the sue the guardian and then recover that money which it has been mismanaged. Then 36 deals with, if a guardian does not give a bond, the next friend at any time can sue the guardian during the pendency of the proceedings. Suppose let us say the guardian fails to give the bond to the court, then the next friend is nearest relative, can sue the guardian and ask for proper accounting even during the pendency of the proceedings. Then, sir, liability of the guardian as trustee. That's what section, general liability. The minor is deprived against any remedy against the guardian or the representative of the guardian, which not being expressly provided, any other beneficiary or his representative has rights against the representative of the trustee. So once a guardian is appointed, be it the father or be it the mother or be it a third person, then in that case if he mismanages the funds, then in that case the next friend or any other person who is interested in the minor can bring a suit and ask the person concerned who is administering the properties to render proper accounts. Right of survivorship among joint guardians, in case, that is what section 38 says, he can function, such vacancy is filled till such vacancy is filled. So suppose joint guardians are appointed, then let us say one of the guardian dies, whichever guardian survives, that person can function in the place of the deceased guardian till a regular guardian is appointed by the court. Then section 39, the court can remove a guardian on specified grounds. Suppose the guardian is not conducting himself properly, he is not acting diligently, he is not acting for the welfare of the minor, he is mismanaging the properties of the minor, he is mismanaging the income derived out of the properties, he is not rendering proper accounts, he is not acting in a transparent manner, then the said facts being brought to the notice of the court can order what is called that particular guardian to be removed from his office. That's what 39 deals with. Then we go to section 40. The guardian can apply to the court in case he wants to resign. Sometimes what happens is it's a thankless job also sometimes. Suppose let us say the guardian is overburdened, he has got his professional preoccupations, he is busy otherwise, he cannot discharge his responsibilities properly. Then he says, sir, I want to resign from my office, I don't want to continue as I pay 10 sections and finishes. I don't want to continue as a guardian for any longer. He can resign from his office at any time and apply to the court to be discharged of his responsibility. This is what we have finished up to section 40. In the next class, that is, we will deal with the section 41 to the end of the G&W Act.